This week's show is brought to you by Studio 47, San Diego's premier recording and production studio. Visit www.globalbpm.com. Welcome to the Nightclub Security Podcast, a professional resource for the nightclub security industry. Whether you're a nightclub bouncer, guard, owner, or operator, this is the podcast for you. We're here to inform, educate, and entertain to help you be your best. Let's get started. Welcome, everybody, to the Nightclub Security Podcast. My name is Manny Marquez. I'm here with nightclub security industry expert Robert C. Smith. We're coming to you from Studio 47 in sunny San Diego. Robert, how are you doing today?
I'm great, buddy. How are you?
Yeah, doing well today. Robert, we got a really interesting show for the listeners today. It's a very important topic, something that we put at the top of our list when we talked about doing a podcast, and I think it's something that everyone's going to be interested in, and that topic is about liability. Just to give the listeners a general idea of what the show is going to be about, we're going to kind of break it up into three segments. The first part we're going to talk about is defining liability. What is it? The second part is how exposed are you to liability? And the third part is what can I start doing today to limit that liability? I think our conversation today, Robert's going to be a little bit free-flowing. I have some questions for you, but there's a lot of topics, so let's get started.
Before we start, Manny, let's be crystal clear on this point. We've got listeners that we know of listening around the world. We want to make sure that they take this as general advice. We're not attorneys. We don't claim to be attorneys. We're going to talk in general terms regarding tort law, civil liability, lawsuits, being sued, time context of lawsuits, and should you find yourself in need of an attorney, go get one. Get the questions you need answered by a real legal professional. If you have other questions that we may be able to point you to, please contact us. But this is general knowledge regarding civil liability.
Of course. Thank you for pointing that out. So, Robert, when we jump into this topic, liability, what is it? I think the first thing that we need to put on the table is, who is this message for? Who are we talking to right now?
Well, it doesn't matter whether you're a dewdrop inn where you're open every day of the week, you're a one-man show, you're the bartender, you're the barback, you're the floor sweeper, the toilet cleaner, or you're a multi-level mega club in the largest city in the world. It doesn't matter. It applies to the owner or the ownership group all the way down to the newest host or hostess at the door. Everyone in between should know and understand what liability is really in front of them when they go to work at this bar or club.
So I'm going to round that out. The people that this message is intended for, or this podcast, we're talking to owners. We're talking to the operators. We're talking to the management. We're talking to the employees within an establishment. So that includes bouncers, security guards, bartenders, the servers, the hostess, maybe even the cooks in the back of the kitchen. This message could also be intended for lawyers.
Yep, absolutely.
Maybe even insurance professionals.
Yep, absolutely.
Who insure these establishments. There's a lot of stakeholders that are involved around this concept of liability within a venue.
I think another one that most people miss are law enforcement professionals. When cops come to your bar, again, bar or club, they're worried about the crime. You may be worried about what happened with the injury and did the person really get injured. The cop doesn't care about all that. They care about the criminal issue they're dealing with. And when you get sued, they didn't do anything to help you cover your lawsuit. So this would be a good primer for law enforcement just to understand the other areas that may be coming up to this business when they leave.
Because that brings us to basically the next question in the definition of this term liability, because you say that covers you on a criminal end. When a police officer makes a visit to a venue, they're more concerned about the criminal liability.
Absolutely right. The cops have one concern, and that is the criminal liability. Was there a crime? Why are they there? And typically it's to handle a crime or to prevent a crime, and that is criminal liability. Real way to understand that for the listeners is if you can get arrested for whatever it is, a bad ID, presenting that ID, putting your hands on someone when you shouldn't, those are criminal issues that you could be arrested for, and therefore that's an easy way to remember criminal liability.
So to clarify, Robert, so if it's something I can get a ticket written for,
that's a criminal liability.
or I can get a fine from my city or state, criminal?
No.
No?
No, that would be administrative liability.
Okay.
If there is a crime that's been committed, that is criminal liability, where you can get a ticket, you can wear handcuffs, you can go to jail, or the cops can just get your name and release you. That'll be criminal liability. I think the area you're touching on at first glance appears like criminal liability. It's actually administrative liability. For example, the cops in your vice unit on your police department or your alcohol enforcement unit may come in and see a violation that they could arrest someone for, but that doesn't serve the purpose of correcting the ABC violation. So they'll write a letter to the ABC. They'll write an infraction notice and submit that notice, and that becomes an administrative hearing issue where now you have to go present your side of the case to really administrative judge, whether it's a sergeant on the police department or it's an ABC beverage control hearing board. So it was a crime that they could have arrested you for, but they decided to handle it in an administrative manner. So
Gotcha.
they wrote a statement and they submit it to have you talk at a hearing.
And then what is the third aspect of liability?
The third one is probably the most costly and almost always the one that's overlooked when we do training, when internally bars, clubs do training, and that's the civil liability. And simply to try to understand it and wrap your head around tort law and damages and this huge umbrella that is civil law, try to simplify it. And the way I teach it is, if there is a harm or an injury and it's caused by someone at your bar or club, by them or by their lack of action. So let's use the simple lime wedge on the floor. If someone slips on that lime wedge, you could be sued. If the bartender sees that lime wedge and just pushes it off to the side and then someone slips on it, you can be sued. And if the bartender doesn't even notice that lime wedge and someone slips on it, you can still be sued. That's why civil liability is such a difficult animal to tame, because there's so many areas that present themselves to employees.
So using your lime wedge example, which is something that I've heard you use before, there's what you did or what you didn't do, correct?
Absolutely.
And so between those two things of what I did or what I didn't do, you can still be sued for.
For example, the lime wedge. Once you know the lime wedge is there, the jury will be instructed, or a judge will know this, but people will be able to evaluate what you as a business did after you knew that lime wedge was on the floor. I know we're talking in simplistic terms, but it is simple if you think of it that way. The lime wedge is on the floor. 3 employees stepped over it. Around that lime wedge are several other lime wedges and napkins. Your bar is in disarray to the normal viewer, because what would a normal business do when they see trash on the floor? They pick it up.
Yeah.
Well, if you're stepping over it and your bar is in disarray, it lays out as you didn't do anything about it. Therefore, you didn't do anything to prevent this person from slipping on that lime wedge.
Which still leaves you liable.
You're open to liability.
Gotcha. So there's the criminal liability. There's a civil liability. Civil liability is the one that's costly. I'm going to get sued for an X dollar amount. When is it that an establishment, a bar, restaurant, nightclub, when do you become liable?
Well, and I've had attorneys laugh when I say this, but when I ask them if I'm lying, they say no. The way I teach it is, as soon as you open your doors, and sometimes even when your doors are locked and closed, your business is liable. I mean, think about that. That's done, period, end of sentence. When you open for business, when you open a business, take out a business license, and you have rent and property and pay electric, and your building is at address X, you're assuming liability, period.
So you're saying from your mere existence of operating as a business, you now leave yourself open to liability.
Absolutely.
Okay. My next question for you, Robert, is I want to talk a little bit about the spectrum of liability. Let's kind of give the listeners an idea of, what's a case or a civil lawsuit, at the bottom end of the spectrum, the simple thing that might happen, on a weekly basis that could leave you exposed. And then we'll spread that out and let's go, what's the extreme? What's the big sort of thing that could happen within a venue?
Well, from the lime wedge all the way to something extremely popular these days is bar and club shootings, where someone is either killed or multiple people are wounded.
So let's start with the lime wedge scenario. Probably something that happens at every restaurant, every bar and nightclub across the United States. The slip and fall. What is that? What does that look like?
Well, for an examination, the female's at the bar. She's wearing her high heels. She's dancing on the dance floor. She's had 3 cocktails. She walks up the little ramp and steps on a lime wedge and slips and falls. Employees rush to help her up. Other patrons help her up. And she says, "Oh, I'm fine, I'm fine." And she goes on continuing to have fun. She has another cocktail, further numbing the pain of that twisted ankle. Her ankle swells up by the end of the night. The next day she goes to urgent care. She can't pay for it, so she decides that she needs to get money to help pay for this. She doesn't want to tell mom and dad about it because she's a college student. She's not supposed to be out drinking when she said she was studying. So she decides to get an attorney and sue. She sues because you should have taken better care for her. You didn't offer her ice. You didn't have better lighted stairs. You left lime wedges on the floor.
Nobody picked them up.
Nobody picked them up. In fact, she claims and her friends claim there were lime wedges all over the floor. But this is not just a week after. This is 2 years later. But the night that the event occurred, the employees did nothing to prove they did nothing wrong regarding that lime wedge. They picked her up. They let her continue to dance because she said she was fine. Let's get her name. Let's document what happened. Let's save that video, and then let's move on.
So on the bottom end of the spectrum, the slip and fall, that's probably something that's in our focus, but that's the bottom end of it. Now, as you go through the different levels of liability, the extreme case is probably death, right?
Absolutely.
And just give me, in your past experience, give me an example of something you've come across that revolved around the liability of a death of a patron or an employee.
Very, very typical, simple bar fight, 2 to 3 people on 2 to 3 people. Guards jump in, employees jump in. They separate all 5 combatants while they're wrestling them down to walk them out different doors. One of the combatants, one of the guests, has a gun and it falls to the floor. The guards pick up the gun. Don't bother to call police because the guest is very apologetic and sorry about even having the gun but now fighting. But when they get him outside and the guest is leaving, he's given back the gun and he fires at the front of the bar 2 to 3 shots, hitting an innocent bystander, killing them who's in line. Now the guest that was standing there had no idea this was going on. The guest that was asked to leave was given back his gun after a violent altercation inside the club, and now driving by, intoxicated, he decides to take a little vengeance as he's leaving at the bouncer who kicked him out standing at the door. But the shooter misses and kills a guest in the standing line.
And so the point being of these two sides of a spectrum is there's the small things that can happen, and then there's larger things that are affecting the lives of people. But in between that is just a myriad of exposures that you leave yourself on a day-to-day basis that can lead to a civil case. And I guess the question is for operators is what sort of things are happening in my establishment that leave me exposed.
Well, and in each of those things, from the lime wedge to the shooting, what did the employees, the representatives of the owner or the corporation, what did they do after they knew of this event?
All right, hold on to that thought because we're going to get to that point in the second part. What I want to ask you next, Robert, is in your experience with the consulting and training side of things, and then you also do expert witness, I wanted to see if you could give the listeners maybe a couple examples of civil lawsuits that you've seen that have a high dollar amount, just to kind of give the listeners an example of, it might seem like something that's inconsequential or something small, but has ended up costing a venue or a business, thousands, hundred thousands, millions of dollars.
Let me give you two. And they'll be opposite ends of the spectrum. It's not a lime wedge slip, but a bar cuts off a guy who's drunk. He's showing several signs of being intoxicated. The bartender points him out to security. The manager comes along. Guards come along. They cut him off, pay his tab, look for friends, call him a cab. He says, no, I'll walk. They let him walk down the street. 20 minutes later, he comes back to the patio of the bar. He's trying to get in. The guards turn him away. 3, 4, 5 times they turn him away. They don't communicate this with each other. But on the 6th time, this guest, who was intoxicated and kicked out of the bar, comes back to the rail, climbs over, and falls off the rail, cracking his head wide open. People rush to help him. They get him up. They don't check for injury. They just know that's the drunk they kicked out. They walk him out the side gate. He doesn't complain. They send him on his way. He ends up going to the hospital. He's got a fractured skull. He's got some brain damage. He ended up settling that case. The insurance company for the bar paid him in excess of $200,000. Now, in person, when I give this training scenario, I use video. And people are kind of pissed off about it, that here's a drunk we kicked out, and he got hurt sneaking back into our bar. How are we liable? Remember the first topic, the first point. You're always liable. As soon as you open for business, you're liable. He got hurt on your property. Are there things you could have done? Are there things you didn't do once you kicked him out? And that's why the insurance company in this case chose to settle. And there's more to that story, but that's just it in a nutshell. On the other end of the spectrum, go ahead.
Interesting side note, because I'm familiar with that case, but there was video, right?
There was good video, funny video.
Yeah, I mean, of the whole scenario. And what's interesting is, as a person from the outside, just your average Joe watching this, you would have thought that bar was covered, and you would have thought that there's, it's an open and shut case. But we'll talk a little bit more about the reasoning behind this, but there was still a dollar amount paid.
Absolutely. And on the large end of the spectrum, the opposite end, the deadly dangerous end, is a case not too long ago. And if you want to, we're not going to mention names during the podcast, but you can go find these on the news or the internet somewhere. There's one out of Dallas where an intoxicated guest is allowed to leave. He's not served anymore, and he's allowed to leave on his own. He's not delayed in any way. He's not offered a cab in any way. He's not steered a different way. They've got plenty of video on him consuming drinks, consuming more to such an excessive level. He goes out to his car, which is parked in the bar's parking lot, monitored by the bar, and he drives, and as he's driving out of the bar's parking lot, he hits and kills one of the bar employees. That jury awarded that family of the decedent over $10 million. $10 million.
How was it? A larger venue, smaller venue?
Fairly large venue. It was, multiple levels, probably had 50 employees working, probably had, 500 to 700 guests in there. But take all that out. They invited the guest in. I understand, I get backlash on this, but they invited the guest in. He got intoxicated. It was time for him to go. And all the things they could have done in between, they evidently didn't do. And I'm not going to give you the specifics on this case, but the award from the jury felt they didn't do enough, and there were damages, and they awarded over $10 million.
Is the business still in operation?
It is.
So they were able to weather the storm of this.
Most smart operators, especially the smart big ones, will have good insurance policies. And then they'll have riders, they'll have umbrella policies, they'll have attachments to help cover these type of damages. The issue I think you're hitting on is, if you're just a small operator and you're running your place and you get a judgment for $2 million, you may only have insurance for $1 million. Well, your only option is to sell the business to make that to make that payment, or to go bankrupt.
Yeah, and then the point that I want to make is that, and the reason why this topic of liability is so important, is the dollar amounts that can be awarded in a lawsuit like this can be so substantial. Not only could it ruin the business, but the owners of the business who now their personal lives affected. Instances where lawsuits will go after personal properties. So it really is something that, it's not just something that affects the business, but you're affecting the livelihood of not only the ownership, but all your employees. And that's the thing that I preach when I run an operation is the little things that we do and the effects that they have to everybody are so significant that even the smallest thing that might seem inconsequential affects the livelihood of all the teammates, the owners, the operators, the managers. So a lot of people are affected by these events.
Well, and you mentioned something that's kind of important, and I started teaching it about 5 years ago when an attorney sued a bar. This attorney contacted me. I didn't take the case where a customer was injured on the bar premise. And he was suing not only the company that owned the bar, he was suing the manager and the individual bouncer. And I've seen that before, but it's fairly rare. But in this case, he won in all three areas. The bar's insurance company paid, the manager ended up paying, and the individual guard ended up paying. Now that poor guard is making minimum wage. He doesn't have $38,000 just to pay off this person that he threw down a back stairway.
Yeah, so his life is affected probably for the next several years.
Not only did the bar fire him after this because they didn't want to fire him before because they thought he would give bad testimony, but they fired him after, and now he's on his own with a county judgment, almost like back child support or back taxes, that he ends up having to pay over the rest of his life, really.
This is the events like this, even the smallest things that happen on a day-to-day basis, can affect people's lives for a long, long time. And that's kind of one of the points that I want to drive home is that not only is the business at risk, it's the management, it's the employees. So this is something that encompasses everybody. Let's go ahead and take a quick break. If you like our show, visit 𝐏𝐸𝐿𝐼𝐶𝑠ecurity.com for more information and access to free resources. Remember, that's www.nightclubsecurity.com. Welcome back, everybody. I want to go on to the next part of our show and talk a little bit about the idea or the concept of how exposed are you as a business. And one of the things that we said right up off the top of the show or in the last segment was just opening your doors, you're exposed. And you and I, Robert, we talk about this idea, we kind of use it as a metaphor of a window of exposure. And depending on how open your window is, the idea of how exposed you are. And, there's some operators that, their window of exposure is wide open. Go ahead. Can you elaborate on that a little bit?
That's another teaching tool that I use to get from the entry-level in-house guard or bouncer to the well-schooled manager. I want them to understand, embrace, accept the fact that you're always liable. I get a question, I'm not kidding you, at least daily from operators around the country that say, Bob, am I liable if? And the answer is always yes, but then I have to go into the story. So I use as a training tool that window, just like any standard old-fashioned house window that you slide open or you slide shut. As soon as you open your doors for business, your window is wide open. But what have you done to help close that window of liability? For example, your window's wide open. You're serving triple flaming shots. You're not carding everyone. You're not carding upon service at the bar. You have no logs. You have no cameras. You're not training. You're hiring Billy Bob and his brother to do your security. You're not doing standard practices. Your window of liability is wide open. You are exposed to the maximum ability if you even have insurance. You're exposed worse because now your business is going to be the loss. To the smart operator, typically national chains, smarter independent operators that came from national chains that will, okay, how do we close our liability window? We provide training. The window closes some. We provide policy manuals to each of our employees. The window continues to close. Video, proper documentation of incidents, calling cabs, having a cab service, having stanchions, having a well-lit front, having enough guards. All of these things that can help lower your problems in an operator's mind also close that window of liability. So yeah, you have enough guards. They have the proper training or licensing. You have enough lighting. You have documentation. You have everything you can possibly do in place. You still can be sued. But now, because your window of liability is so closed, you're not exposed to the damages you were as the first operator we discussed. Now your insurance company can say, wait a minute, we're going to fight this lawsuit. We're not going to just pay you because we know we're going to lose in a jury trial. We're going to fight, and we may win. Yes, we may pay out $4,000 to make you go away, or $10,000, but that's a win when they're suing for $500,000, $700,000.
And the window, the idea of a window metaphor, and we always come back to a dollar amount, but I think as we close that window of exposure, we're basically limiting the dollar amount that we pay out on a civil liability. And I think another important point is, can you ever close that window completely?
That window is never closed,
right,
no matter what you do. Even, I mean, think about it. If you really live by that open window, closed window, window of liability, even when you're closed, you lock your doors, you turn on your alarms, your parking lot is closed, and you're home, you can still have some liability exposure. It may not be much. Your window is almost closed, but it's never all the way closed.
And that goes into my next question, which around the concept of liability is, courts will ask the question, reasonable care. And I want you to explain to the listeners a little bit more about this concept of reasonable care.
Again, and I have to draw back on everything I use in my training nationwide. When I train a bar, and I've got to get the bouncers, managers, owners to understand what I want them to learn and maybe take back to their shop, I use the terms you just talked about, reasonable care. So I asked them, if you were going into a bar and you wanted to feel safe, what would you think would be reasonable for a bar to do to make you feel safe? What's reasonable? Manny, let me ask you, give me one thing that you think and you got to put yourself not as an operator, but as a layperson. What would you think as a layperson, just a guest at a bar, what would you want them to have so you can be safe?
I think the first thing that comes to mind would be security.
Okay. And that's one of the things that would be reasonable in almost all bars and clubs. Why? Well, you serve alcohol. Alcohol is a mind-altering drug. It is what it is. Don't get mad at me. It is what it is. Guests come to your bar. You invite them in through Facebook and social media and other advertisements to drink. Many of your guests will get intoxicated. Some of those intoxicated guests that you invited into your building will cause problems. If you don't have security, people that are trained professionals and in some states licensed, you're going to have trouble, more trouble. So that's just one. Typically, the layperson will say, well, I'd like them to have fire extinguishers. That's reasonable for any business to have fire extinguishers. What about proper lighting? So in the event of a fire or a disaster or some emergency, I think that's reasonable. Other reasonable things might be server training, guard licensing.
And you're talking about server training as far as over-intoxication.
And there's many server training programs out there. We're not endorsing any of them, but TIPS, TAMS, RABs, national online programs. There's plenty of them out there. But a layperson, a normal person might think, yeah, that's reasonable that a bartender should know what the signs of over-intoxication are. How much alcohol is burned in the liver in an hour. I think that's reasonable. If you're serving this substance, you should know a little bit about it. And when you start really looking at what is reasonable, boy, there's a lot of things that a layperson might think, well, that's reasonable for a bar to have.
And I think the important thing about the idea, the concept around what is reasonable, is because we can't, obviously, as a society, as a system, the courts can't write everything that you're supposed to be doing. So the idea of what is reasonable covers everything in between.
Well, and once the group understands, okay, now I understand why they mean by reasonable. Yeah, I agree. It's reasonable to have security if you're doing these type of events or these type of things. But let's move into the middle of that, where is it reasonable? Would you think it's reasonable that if you had a fight in a bar, you separate the two fighters?
To me, that's reasonable.
Yeah, it's a no-brainer, right? But some bars think they can allow the fight to move right outside onto the sidewalk and let it continue.
Or the other side where they kick out both parties onto the street.
And the fight continues. That's not reasonable. Not only is it not reasonable, it's not the industry standard. I think any of the listeners that are at least listening are smart enough. Not only are you smart enough to listen, but you're smart enough to realize that you separate fighters, you calm one down, you get one out the door, and then later you get the other one out. Because reasonably speaking, if you don't, the fight's going to continue.
And also around the idea of reasonable is I think the concept comes down to common sense. And what are the actions of the employees at that moment in a common sense fashion that would be reasonable to mitigate or limit the danger or the opportunity for harm to come to someone else.
That's the last part of what you said. What would be reasonable to limit the chance of harm to occur? And it's not something that you're born with. And I once again, I use the training tools of some common sense things for people to learn by. And if you're served a bowl of soup and there's a fly in the soup, the server should know, oh, I'm so sorry. Let me get you another bowl. I'm so sorry. Notify my manager. Let my manager try to make this right. That seems like common sense. Well, it's not.
Well, both you and I know that as time progresses, it almost seems as if common sense is not that common anymore.
And now throw in the security and liability side. If there's no common sense, there's no reasonableness, my job becomes, more lucrative because more people hire me, but the job itself becomes more dangerous because that bar who doesn't use reasonableness as a standard to create a safer environment is more unsafe.
And I think for the listeners, this going back to the whole concept of what is reasonable, I would like every owner operator to think, is this a concept or an idea that I teach my employees? And I'm guessing most of them don't.
Well, you and I have had this discussion on a personal level for over 10 years. My worry is the security and safety and liability of clubs. You as an operator, you're worried about that too. But you're also worried about the temperature of the soup, the color of the paint, the tear in the carpet, the hiring the best DJ.
Wiping down the table.
Wiping down the tables. Picking up the napkin that's on the floor. You're worried about 30 things where I'm worried about one. And getting you to expand your level of worry to also include that as just an important level is vital to create a safer environment.
We could do a whole show on the topic of the thoughts of a manager and how to incorporate these ideas of liability into it. I think probably we will do another show around that whole idea. We've talked now about what is reasonable. I'd also like to talk a little bit about the idea and the concept of a national standard, which kind of ties into what is reasonable.
And that's a question that comes up. You know, you're not going to be at your bar in Georgetown in Washington, D.C. or down in South Beach, and your bartender is not going to turn to the bouncer and say, hey, what's the national standard on when you can use force? It's not the conversation that comes up in a typical manner. And I would bet before you knew me, you didn't even think
I did not know
national standards. So again, in training, the people that I train have to understand that there is a national standard. For example, I mentioned one regarding fights. The industry standard nationwide for two people fighting, it seems obvious and common sense to break up the two fighters, get one out after so they can both leave in a safe manner and continue their evening, and your liability window is still closed or shut somewhat. That's nationwide. A fight in Anchorage, Alaska or Tampa, Florida, that's what they should be doing because the industry standard among a majority of the bars and clubs nationwide, that's what they do, and therefore that's the industry standard.
Who defines the national standard?
The industry itself does.
Okay, so we're talking about associations.
Well, it starts at the very bottom, from the bar to the club to the chains, the state associations, national associations, but now you have to throw in, not now, but also throw in the legislative groups and the enforcement groups. And let me use one example to get people to wrap their head around this, is the national standard, the industry standard for service of alcohol. There are 4, and it's been used for over 30 years. The standard amount of alcohol is the same in 4 types of drinks. And it's taught, and people know this standard. And I can walk into almost any bar in any part of our country and ask them.
And you're basically talking about the idea of 1.25 ounces is a standard shot.
1.25 ounces is a
industry
standard.
standard.
Industry standard. A 12-ounce beer, 5.5-ounce glass of wine, 1 shot, or a 1.25 ounce of 80 proof, or 1 shot of 100 proof. It's the same. It's the industry standard. But we don't teach those standards regarding safety, liability, and security.
Most of the time. But that's what we're here to do.
That's what we do.
So again, the idea of a national standard, those are the standards that are set by the operators, the industry as a whole, associations surrounding the industry, law enforcement, legislative bodies. So collectively, these ideas, concepts are what set the national standard.
Absolutely. And you got to be real clear here. I've been asked this, in trials as an expert witness. Mr. Smith, what is the national standard for this? The next question after I answer that will be, Mr. Smith, what is the legal standard? What they're asking me is there a law that says that? For example, the industry standard for the number of bouncers in a bar nationwide is between 1 bouncer per 50 or per 75 or per 100 patrons. So the industry standard is 1 per 75.
Gotcha.
In California, there's no legal standard. There's no law that says you have to have 1 guard per 75 people. They go by the national or the industry standard.
Gotcha. So now that we've defined national standard, the next thing that I want to talk about, and it's to me a very interesting concept, is when a lawsuit happens and you now put the question of who was liable or how liable were they. The idea of to shock the conscience of the court. And this is a term that I learned from you, and I think that it really puts in perspective from an operator standpoint just how far do you go. So can you put the term to shock the conscience of the court in perspective?
I first learned that term tied in with when my first class I ever gave in 1998 was to a group of, and I'll throw them out there, a longtime client is 𝐍𝐶𝐿 Consulting here in San Diego. I trained 50 guys, and the second question I got from this group of bouncers, and this is 1998, and some of these guys were pretty hardcore, are you going to tell us if we can beat the shit out of people or not? And in answering that question, in my mind, I'm thinking of 20 other questions. That night after training, I went and started looking all this stuff up so I would never be stumped again with that type of question. And one of the things I learned from a judge, and then I found many judges and juries and other people have said this nationwide, is the appropriate use of force, and the force or the thing you did, whatever it was.
Whatever action you took
regarding force or whatever it was, should not be so egregious and over the top that it shocks the conscience of the court. The court is, in our term, the jury or the judge. So whatever you did better not be so over the top that the layperson, a reasonable person, would think it's shocking.
So one example that I remember was the picture of a gentleman whose face was used to open up a push bar door. And the guy his face was just bloodied, I think a broken nose. They took the picture of the guy afterwards, and you use that as an example. If the jury was to see that photograph, would that shock the conscience of the court?
And it's funny, and I say it's funny, and I don't mean that in that way, but this case this case settled out of court. The insurance company got the papers that they were suing, and they settled. But the photo itself even shocks hardened bouncers, guards that have they're former military. They've seen blood. They've seen guts. And when that picture comes up on the screen and they realize what it is, they're gasping. Oh, man. Oh, because it shocks even them. Now imagine if that goes before a jury and you've got, Susie soccer mom and Madge.
The average peer, your average American.
The average American juror, they're going to look at that and they're going to look at you with a death stare if you're the plaintiff. I'm sorry, if you're the defendant. That would shock the conscience of the court, that type of injury.
And the reason why I want to bring up that concept is to let the listeners know that when you think about your actions in dealing with this situation, and the easy example to go to is I have to use force to get a patron out the front door. How much force do I use? And I think it's important for the listener to understand that has to be reasonable. Okay. Whatever you use, the end of it would not be able to shock the conscience of the court.
Well, and what's really and difficult for me, and I want to say it's sad, is that the guards do everything right. And I've worked with clubs around the country, and they do everything right. They identify 2 guys that are causing trouble. They address them. They notify management. They've got video rolling. They've cleared the path. They're going to walk them both out. They've got plenty of people to do it. Everything is done right. These guys are spot on. But right when they get to the door, one of the guys turns and pushes the guard, and the guard loses control, and he pushes back. The guy falls backwards. The guest falls backward, hits his head on the ground, and splits his head open. And everyone is like, what happened? The guard lost control in that brief moment, and that moment caught on video with the guest falling like a limp rag doll, hitting his head and cracking his skull open, is unreasonable. And it's shocking, even though he did push the guard's actions were unreasonable. And your window of liability shoots way open for being liable.
In those scenarios, one of the things, and you mentioned it in the first part of our show, the life cycle of a lawsuit. And this is something that, as an operator, I would say not a lot of people understand this or even give it any thought, but it's something that's very important because that opens up the window of exposure. And I want you to give the listeners an idea of what is the life cycle of a typical lawsuit, kind of get in the mind of a lawyer, and what does that look like?
Well, and remember, our industry is really sort of disconnected when it comes to this stuff because it doesn't really affect that many employees that much. So the typical life is someone in your bar gets hurt. There's a harm. Let's not even describe how, but they get hurt.
Let's do the slip and fall.
Well, let's not even call it a slip and fall because it can be anything from the shooting all the way, anything we've discussed that could fall into that window of liability. An incident occurs in your bar that there's a harm. Okay, that guest leaves. 4 days later, they go to the doctor. 6 weeks later, they're finally healed. Remember, the bar, it's now 6 weeks out. They know nothing about it. Another 2 months later, this guest finds out that they can't pay for the hospital expenses. They've missed work. They're having trouble with their own life, maybe some post-traumatic stress based on this incident inside the bar, your club. Now it's a year away, and they hire an attorney. That attorney takes them into their office, finds out all the information about the lawsuit. And let's use California for an example, where you have a 2-year window to sue someone for a harm. The tort law.
The statute of limitations.
That's the statute of limitations, 2 years. So they're not going to come back. If I'm a smart attorney, and if you're listening, it is what it is. They're going to wait till the 363rd day of the second year to file that lawsuit. They're going to come to the bar. They're going to deliver the demand. They're going to deliver the lawsuit paperwork, and they've legally filed it in court almost 2 years to the day from the incident when it occurred. Now think about that. Someone gets hurt in your bar. 2 years later, you're given papers. You're being sued.
2 years? I don't even remember 2 years ago.
You may not even be the same manager.
I wasn't even here.
You weren't even involved in it, but you're getting the papers.
Who's J.J. Martinez?
Nobody knows who Jose is or who anybody else is. But now they filed their suit within 2 years. Now it goes through the court processes. It's another 6 months. It's another 8 months. And finally, you get more letters from the attorneys demanding video, demanding employment records. Who was working that night? What was your capacity? Where's the incident log from when Mr. Martinez was hurt? All this paperwork that they're asking for through what's called discovery. You have none of it because you didn't even know this was going to go to anything that night. No police were called. Mr. Martinez was in a fight or whatever the incident was. He was escorted out. Now he's claiming several things happened to him. And you have to defend yourself. That's our system.
And the point being is that an attorney for the plaintiff, this is a very calculated move because they know that time is on their side.
It's not only on their side, it is one of their best allies on their side. For example,
because as time goes by, all memory or most of the memory deteriorates.
And that's a normal thing. But one of the biggest negatives of waiting for the operator, DVRs. Your guys did everything right. You separated the fight between Mr. Martinez and Mr. Jones. You walked him out peacefully. You shook hands with him at the end of the night. But the video taped over in 30 days.
Yeah.
You didn't write anything because no police were called and no, there were no injuries that you know of. But when you separated the fighters, you had to put Mr. Martinez in a headlock. He didn't complain of pain to his neck. Well, that's a classic whiplash. The next day, he wakes up. Could be he slept funny on his pillow. But it's because you put him in a headlock maybe that he has neck injury. And he waits the 2 years to sue. No video, nothing written. 3 new guards. The 4 guards that were there are not there. You have a new manager. Everything is on their side. So the idea here, that life of the lawsuit is really a 2-year, 3-year, maybe even 4-year cycle. But the incident happened on a Wednesday. What did you do Wednesday, Thursday, Friday to protect yourself 4 years down the road? Did you save the video? Well, he wasn't injured, but let's write something anyway. We have witnesses. We have the license plate of the driver that took Mr. Lopez away, and now we know who that person is, and they said he wasn't injured. In fact, if it were to come out, Mr. Lopez, they drove to another bar and partied for another hour, clearly showing he wasn't that hurt.
And the point being is that no matter how large or small an incident is, it's has to be in the mind of the operators and the employees that there needs to be some sort of trail. And we'll talk a little bit more about documentation in future podcasts, but because that's a whole other show topic. But the important part is that they're going to catch you off guard, and most of the time you're going to be left exposed with your pants down, not knowing what happened that night. And I think that's just a major point that we got to drive home to the listener. I wanted to also talk about a spectrum, a range of what these operators look like. And we'll do that real quickly because we're running short on time here. But give me your garden variety, the guy who's not doing it right, and then show me the operators who are doing everything they can to limit their liability. What do those two types of operators look like?
Well, I'm working with a group now. They've got about 9 different venues. And when we started working together 2 years ago, they had 5 or 6. And when they hired me, it was almost like I could write my own check, a blank check for this. They saw through some preventable losses. And by the way, I really believe, I really believe that civil lawsuits are the largest preventable cost that bars, clubs, and the nightclub industry face.
Hands down.
Hands down. Largest preventable. Not employee costs, not carpet, not air conditioning. These are preventable things that bars can do. This group of clubs saw that they weren't documenting. They weren't hiring the same. They weren't training the same. They didn't have standards for their own employees. And they brought me in to do that. They brought our company in to do just that. We wrote policy manuals. We did standardized training. We taught them some simple HR rules to do regarding their guards. We did some things that, although they might have known about, they didn't know how to implement them. We also did something very important with this group. Every incident that occurs that could lead to any sort of liability, they write paper on, and we review it a day or two later. While it's still fresh in your mind, while we can still get video, while we can still find witnesses, because we're worried about the 2 years away that the lawsuit may run.
So that's on one end. That's the good operator. What does the other guy look like?
The other operator I've worked with for a little bit, and once I realize their head's not in it, I have to check out and tell them, look, when you're ready to do this, I can help you, but until you're ready to take hold of your bar and do it right, I can't. For example, hey, Bob, we want to hire you to do training. Okay, here's the layout. This is what we're going to do. Well, can we do it instead of 8 hours? Can we do it in about half? Because a lot of my people have other jobs. No, we can't. It's an 8-hour program. Well, I don't know that we can do it that way then. Well, what about doing our online training program? Well, I don't know that I'm going to get them to be able to pay for that. Well, labor law says that you have to pay for it anyway. I can get you some discounted vouchers and we can get the expense down for you. Well, I don't know. Let me check back with you. Okay, let's look at your paperwork. Well, we don't really have much. We keep incident logs of violent incidents. Let me look at a couple of them. Well, I just can't find them right now. That's an operator who doesn't really want to take control of their own destiny.
And I think there's even probably somebody lower on that scale, and that's the guy who's not doing anything. It's probably the individual who, owning a bar sounds like a great idea. I'll be able to meet girls, have a good time. My friends can party. The operator who allows his employees, maybe himself, to drink on the job. It's just the irresponsible operator who, and we've seen this. Like I said in the last show, we've gone to towns where we watch into bars and it's in disarray. It's what you would call a disorderly house. And that person leaves themselves totally exposed and probably doesn't have a leg to stand on if a lawsuit was to come his way.
I want to lay this out to you. I bet your point's right there. One of our listeners, I guarantee you, will send us an email. And this email will come from a bouncer. He's minimum wage. He's done it for 12 years. He likes the bar. He sits in a bar stool, does a great job at the door. Everybody knows him. He's a wonderful worker. And he sees things within his own bar that he can't correct because he's just a worker. He sees they don't save video or they have no cameras. He sees they don't document. He sees they don't pick up lime wedges. If they're not picking up lime wedges, they're not walking out people through separate doors. This guard, he or she, will see that and want to fix it, but they can't. They don't have the power to do it because it starts with the owner wanting to do it, the manager implementing it, and everyone else following it.
And that brings me to the next point is who's responsible to manage these risks. And I'm going to give you my perspective because I've worked for many types of different types of ownership. And it's my belief that the responsibility lies on ownership. This has to be a top-down approach. If you have a manager driving all these ideas in a way of doing business and the ownership doesn't buy in, something's going to get missed. And I really think that for the owners listening, you need to understand the importance of setting the standard, pushing that down through the ranks of your employees, including your management, and being able to carry out this level of operation. Because if you're not buying into it, no one else is going to buy into it.
You're right on with that point. And from the first year I started this company, that's what I've been trying to convince people. One of the things I put in my training programs for a single operator, for example, there was an operator in Tampa, Florida that brought me in to do training for a weekend. Part of the contract was day one, for the first day of a 3-day training session. We were doing about 20 hours of training plus nighttime on the job training. Day one, the owner of the company had to be there for your exact reason. I needed the worker bees to see the owner there, and I needed the workers to see that the owner bought into this, from using new documentation methods, new customer service techniques, new entry and exit techniques, new hands-on policies, new screening policies. The owner bought into it. He had had enough. He had had plenty of lawsuits, plenty of trouble from the police. Not only did the owner buy into it, but I made the owner personally invite law enforcement authorities. Now the cops are buying into you doing it right, and the owner now has a stake in it. The owner didn't realize why I wanted the owner to invite the cops, but after day one, he said, now the cops expect me to do this. Yeah, now you kind of got to buy in the game. You bought into this, but you're holding a share of this to show the police you're doing it right. Once that owner bought that, the newest bouncer he had came to me later and said this is the best training he's ever had. Not only is it the best, he knows he has to do it because the boss said to do it.
Yeah, it's got to be a total buy-in, because if a link in that puzzle is missed, then again you're leaving yourself exposed.
Real quick, Manny. One point on that, and for you listeners, I know what some of you are thinking. Bouncer, you know what I'm telling you, that you can't make these changes. There comes a time when you know you shouldn't let in underage people, and your manager or owner who wants to live vicariously as an old guy with a bar comes to you and says, nah, go ahead, they're okay. And you have to let him do it or you're going to get fired. Or the intoxicated guest that's a regular who's a good paying customer because he spends $200 a night, the manager says, no, he's okay, we'll just watch him. And you can't change that. I got to tell you, bouncers, if your owners and managers don't want to buy into doing it right, don't get mad. Go find another job. You want to do it right. You know what should be done. You either take it and shut up, or don't take it and go find another job.
Robert, I knew this would happen. We've already gone through our first 2 parts, and we're at our 50-minute mark. We like to keep the shows a little bit under an hour. So what I'm going to do is I'm going to suggest that we break here, and we actually break this up into a 2-episode topic. And I think next week what we'll do is let's talk about the ideas of how do I limit my exposure? What are the things that I can start doing today as an owner, operator, manager to limit this liability? And I'm sure we'll have an entire hour to talk about, because I think it's probably one of the most important aspects around this idea of liability is what can I do?
And not only the owner, operator, manager, but for you bouncers, first line defense guys that are out there walking the floor as ID screeners, floor walkers, door hosts, there are some absolute great things you can do on your own to limit your liability, your personal liability and your bar's liability, even if you can't get your owner to buy into the things we've talked about.
And just the mere fact that you're listening to these podcasts is a good resource to better your understanding of that, what we call reasonable amount of care.
We talked about that before, and I love it when, I don't care what side of the plaintiff or defendant case I'm on working, but when I have a bar I'm working with and their guards are knowledgeable of what this procedure is and what civil liability is, I know that I can honestly say, swearing on a Bible, that this guard, their knowledge, their actions are above the standard of care. And remember, we're talking about the industry standard where there's a line in the middle and there's below the standard and above the standard. A guard that can say, I've been trained, I listen to these podcasts, I've learned what this is, I understand what this is, you're automatically above the standard and the jury loves you.
Before we just wrap up the tail end of the show, and I got a couple things for our listeners, I just want to remind everybody what we're talking about as far as we're not lawyers. This is merely discussion topics. If you have questions, concerns, please seek the advice of legal counsel.
You know, and also, I know we have a couple of attorneys that do listen. You guys are more than welcome to send your points and your ideas on what this industry should be aware of, and we'll be happy to put it out and maybe even invite you in.
Yeah, and on that topic, if there's any feedback, questions, our listeners can always email us at questions@nightclubsecurity.com. All right, everybody, that about does it for our show for today. Thank you for listening. If you did enjoy our show, please share us with your colleagues and peers. Let them know that we're out here, where to find us. You can find us at nightclubsecurity.com/podcasts. We can also be found in iTunes. We're under the business category. Search for Nightclub Security. If you liked our show, we would like to encourage everybody to give us a 5-star rating if you think we deserve it. Any sort of feedback, comments on the iTunes or on our podcast page are greatly appreciated. If you have questions, again, you can reach us at questions@nightclubsecurity.com. If you're a bouncer, owner, operator, and you need more resources, you can find us at nightclubsecurity.com. We do offer a range of services, including consulting, training, both in person and online, investigations, and expert witness. If there's anything we can do for you, please let us know. We'd love to help. That's all for us. Until next week, my name is Manny Marquez.
And I'm Robert Smith.
And be nice.